Order. I call Tony Vaughan to move the motion.
Thank you, Mr Dickens. It's always a pleasure to serve under your chairship. I beg to move that this House has considered E-petition number 7014 relating to decriminalising abortion. The petition creator is Gemma Clark, and this is what her E-petition says. I'm calling on the UK government to remove abortion from the criminal law so that no pregnant person can be criminalised for procuring their own abortion. I know that Gemma became involved in campaigning on this issue during the pandemic. She was particularly alarmed by the tactics of some campaigners who were harassing women trying to access abortions in Scotland. And Gemma also has a friend who's experienced a stillbirth but was then investigated by the police. She is worried that there is a lot of misinformation around abortions, especially late-term abortions, and this is linked to the rise of extreme ideologies and misogyny. She is a primary school teacher and is fearful that the young girls she is educating now will have fewer rights when they grow up than she does. I thank Gemma and the over 103,000 people from across the UK who signed her petition, which includes 152 from my constituency of Folkestone and Hythe. And I also want to thank 55 of my own constituents who emailed me to express their views on the issue, which have fed into this speech. Now, how is abortion criminalised in the UK? Well, it depends where you live. Abortion is effectively decriminalised in Northern Ireland, whereas in England, Wales and Scotland, long-standing laws maintain the criminalisation of abortion. In England, Wales and Scotland, there are two main offences: procuring miscarriage under Section 58 of the 1861 Offence Against a Person Act. The second is child destruction under Section 1 of the Infant Life Preservation Act 1929. Yes.
In describing the law, one of the justifications behind the 67 Abortion Act is it would end backseat abortions, and indeed we do have abortion on demand in safe environments, whether you like it or not. I'm just wondering whether he thinks that if these proposals go ahead and de facto it becomes possible to have an abortion at home up to birth, this could endanger women's health. And is he not worried about that, or is not the movers of this petition worried about that?
Tony Vaughan.
I'm grateful for the Honourable Member's intervention. I'm not aware that following the decriminalisation of abortion in Northern Ireland there has been a strong current to recriminalise it, which might be met if, for example, the situation that the Honourable Member referred to as increasing had actually occurred, but that is not my understanding. So in relation to each of those two offences, sentences of up to life imprisonment apply. And in relation to child destruction, a person is guilty of that offence where the pregnancy is at least 28 weeks and they commit a willful act causing the child's death, and it's a defence if the act was done to preserve the mother's life. The procuring miscarriage offence can be committed at any stage of gestation where a person uses a poison or instrument to induce miscarriage, and there are defences variously, as the Honourable Member says, under the Abortion Act, where two registered medical practitioners authorise abortion in an approved clinic in broadly four situations. One, where there's a risk of injury to the mother's physical or mental health up to 24 weeks, and that was the exception that was expanded during COVID so that women could access pills for medical abortions at home for a pregnancy of up to 10 weeks following a consultation. The second and third exceptions, yes.
Carla Lockhart.
Point the Honourable Member made around Northern Ireland. I think it's important to note that Northern Ireland does not have at-home abortions. We don't have pills by post, and much of the decriminalisation of abortion in England and here in the mainland is focused around the at-home abortions. So Northern Ireland is a very different context, and I don't think it should be used in the same train of thought.
I note the Honourable Member's point. In relation, yes.
I think in a different way. Of course, it's worth noting that the Northern Ireland Human Rights Commissioner has explicitly called for telemedicine to be made available to women in Northern Ireland. And because we have a human rights framework in Northern Ireland, the government has to respond to that or risk being taken to court again by her for failing to uphold the human right of women in Northern Ireland to access a safe and legal abortion. We have no such protections here in England and Wales as yet. Is that not the case?
My honourable friend is right, and of course it was a 2018 Supreme Court decision in the Northern Ireland case which showed that those rules, as were then enforced, violated the human rights of women. And that has to be at the centre of considerations that we have around this issue. Just to finish off on the exception so I can get into the points: risk of grave or permanent injury, risk to the mother's life, substantial fetal abnormality are exceptions without any gestational time limit. And I'll just press on because I'm conscious of the time, and maybe that we come back to that. All right, okay.
Jim Shannon.
The reason why I know
So
3 hours,
10 minutes,
I checked with Mr Sherman before to ensure that we'll probably have ample time to speak, but just for the record, I think it's important while the abortion legislation we have in Northern Ireland, I say this respectfully to the gentleman, he knows I do this in the way that I always try to do it. The legislation for Northern Ireland was imposed by Westminster upon Northern Ireland because we had the Northern Ireland Assembly was working at that time. Therefore, the elected representatives never had a chance to have an input into the process, and the people of Northern Ireland, according to the polls that took place in Northern Ireland, were very much against the type of legislation coming in. So at the end of the day, when the Honourable Gentleman refers to Northern Ireland and the legislation, it's a Northern Ireland legislation that we, government opposed here, but Northern Ireland had no input into.
Tony Vaughan.
I thank the Honourable Member for his intervention. I do kind of come back to what I said to the Honourable Member on the bench opposite in terms of I'm not aware, whatever the position may have been at the time of those laws coming to force, I'm not aware of there being a movement or a democratic support for changing the law back to what it was before. And I think when we're talking about whether laws meet the current standards of societal norms, I think that is the most important thing. But I want to turn now to how the law is being applied in England and Wales. Until 2022, it was believed that only 3 women had been convicted of having an illegal abortion in the 150 years since the 1861 Act, which is under which most illegal abortions are prosecuted. But there has been a recent increase in the prosecutions of women for procuring miscarriage under the 1861 Act. The CPS has reported that for the period January 19 to March 2023, 6 people were charged with child destruction and 11 were charged with procuring miscarriage under Section 58 of the 1861 Act. Now, one of those people was Nicola Parker. She took home abortion medication following a teleconsultation, believing that she was less than 10 weeks pregnant. She was in fact 26 weeks, accused of having an illegal abortion. On the 7th of November 2020, she was in hospital. The next day... yes.
Order. Can I just clarify whether this is a live case or not?
My understanding that this has been disposed of. She was found not guilty of those charges last month, I believe. Yes.
Catherine Fuchs.
I thank the honourable gentleman for giving way, and would my honourable friend agree with me that the best way of keeping the protections that women have now to have an abortion and also to stop the criminalisation of women that you've been talking about is to support the upcoming new Clause 1, which my friend, the Honourable Member for Gower, is bringing the new Clause 1 to the Crime and Policing Bill.
I thank the Honourable Member for her intervention. I agree and I will support that amendment. So Miss Packer was in hospital one day, she was arrested the next, and it took 5 years before the courts could dispose of that case. Carla Foster is another situation where a mother was jailed for illegally taking abortion tablets to end her pregnancy during lockdown. She was sentenced initially to 28 months in prison. This was a mother of 3 who had been somebody of exceptionally good character and who had suffered from poor mental health. She had quickly admitted to police that she had provided incorrect information during the consultation. On appeal, the Court of Appeal reduced the term to 14 months and suspended the sentence. But by this point, she'd already served 35 days in prison and had been denied any communication with her children, one of whom was autistic. And in reducing her sentence, the judge said that this was a case that calls for compassion and not punishment, and that there was no useful purpose in keeping her in prison.
Would you agree?
Yes.
On that point?
Kim
I thank him for this important debate. Would he agree with me that at the heart of this discussion are some key principles? He's mentioned one there, compassion, but also choice and bodily autonomy. And whatever stage we're at our lives, it's important that we're allowed to make choices about our own bodies, free from fear of criminalisation or judgment.
Tony Vaughan.
I entirely agree with the Honourable Member and thank her for her work on the Terminal Adults Bill, which engages that principle of autonomy. Now, I find it hard to read about those cases that I just talked about and not feel that the time has come to abandon the practice of criminalising and imprisoning women for choices they make about their own pregnancy. Yeah.
I thank my honourable member for giving way, and I thank all those people that signed the petition to make sure that we had this debate. Is he aware that over 200 women have actually been investigated for this? And is he aware, and does he agree with me, that some of the police tactics that are then used by using crime scene tape and excluding families from their own family home, removing children, even in cases where no charges are brought, is extremely traumatising to the family and to the woman who has suffered the loss of a child, whether by her own decision or because of a miscarriage.
I thank the my honourable friend for her intervention and for noting that statistic, which I wasn't aware of. But it does make the point that criminalisation involves traumatisation all the way through, from the moment of investigation to charge, to arrest, and all the way through the system, which is why I was saying that the time has come to abandon these outdated practices. And I struggle to see how it can be a good use of the scarce resources in our criminal justice system to prosecute and imprison women in these situations. Now, I believe that our laws cannot be fixed relics of the past, but must reflect social attitudes and societal norms. A YouGov poll of 2,098 adults in September 2023 found that 52% of respondents believed that women should not face prosecution for having an abortion, while only 21% of respondents believed that prosecution was appropriate. At the international level, and as the petition creator Gemma White Clark has rightly reminded me, the World Health Organization's 2022 guidelines on safe abortion recommends removing medically unnecessary policy barriers to safe abortion, such as criminalisation. And more than 30 of the organisations representing medical practitioners in this country support decriminalising abortion, such as the British Medical Association, the Royal College of Nursing, the Faculty of Public Health, the Centre for Reproductive Rights, the Royal College of Midwives, and the Royal College of Obstetricians and Gynaecologists. And Dr. Rani Thacker, the President of the Royal College of Obstetricians and Gynaecologists, has said that abortion that happens outside of the current law generally involves very vulnerable women, including those facing domestic abuse, mental health challenges, or barriers to accessing NHS care. Yet, alarmingly, prosecutions of women have been increasing in recent years. Abortion is an essential form of healthcare and should be subject to regulatory and professional standards like other medical procedures and not criminal sanctions. As I've mentioned, Northern Ireland repealed the criminal provisions that we referred to. In a similar way, my honourable friends, the member for the Gower and the member for Walthamstow, have proposed amendments to the Crime and Policing Bill which disapply those provisions, which would eliminate the risk of prosecution for women who self-manage abortions or seek care beyond current legal limits. Now, in relation to the member for Gower's amendment, access to abortion services would remain exactly as it is, as I understand it, including as to time limits, grounds for abortion and the requirement for 2 doctors. The member for Walthamstow is in a much better position than me to talk about her amendment will follow similar principles, but I won't stray into her territory by saying more at this stage. But the key point here is it's about regulation. It's about maintaining the situation where you have regulation, but criminalisation is a very different matter. I appreciate there are organisations who are passionately opposed to decriminalising abortion. I believe that decriminalisation does not mean deregulation. As I've said, my honourable friends and members for Gower and Walthamstow propose to maintain a body of rules on access to and provision of abortion, such as the existing time limit, which would remain in force. I understand that some people claim that decriminalising abortion would lead to significant increases in the number of women performing dangerous late-stage abortions at home, as has been suggested. But I think this would be highly unlikely, as the latest figures available from 2022 reveal that 88% of abortions were performed at under 10 weeks gestation. And I've not seen, as I've said in response to interventions, evidence to suggest that removing the criminal law deterrent would then motivate swathes of women to have abortions after 24 weeks. And indeed, in Northern Ireland, I haven't heard of any campaigns to recriminalise due to unforeseen consequences. Yes.
I thank the member for giving way for the excellent speech he's making. Many of my constituents have contacted me and I support the amendments to decriminalisation. Does he also recognise that this would bring us in line with other countries, including France, Ireland, Canada and Australia to note a few countries?
I thank the honourable member for her intervention. It is noted. Yes.
Carla Lockhart.
The honourable member for giving way, and he mentions other countries and that there's no evidence to say that it will increase abortions. What would he respond to New Zealand, where abortion was decriminalised in March of 2020, And since 2020, there has been a 43% increase in late-term abortions between 20 weeks gestation and birth in the same year compared with 2019.
I'm not aware of that statistic, and it may be that I can look into it and say more about it in closing. Now, yes.
Tom Hayes.
Thank you. This Parliament must protect women's fundamental healthcare rights. That's what nearly 200 of my constituents have said in signing this petition. That's why I have co-signed Amendment New Clause 17 to the Crime and Policing Bill proposed by my honourable friend for Walthamstow. We face a global backlash against abortion access. The US Vice President has criticised our buffer zones, citing a case in my Bournemouth East constituency. I visited the clinic that was identified by the Vice President. I've met with staff. They deserve safety and freedom from harassment. They've been concerned about the tampering and vandalism of their vehicles. They're concerned about rising hostility. Would my honourable friend agree with me that many of my constituents deserve fundamental human rights? We must lock in these rights, prevent future rollbacks, put them beyond the reach of politicians, and does he agree that we need to end the threat of prosecution and decriminalise abortion?
I agree with my honourable friend and thank him for his intervention. And as Member for Walthamstow said, as I've said, these are human rights issues. Courts have highlighted incompatibilities where that has been the case, and it's important that those principles guide our approach to this. I'm in favour of regulation of abortion, but I'm also in favour of decriminalising it, so that abortion can once and for all be treated as the law as a matter of healthcare, not criminality, and so that individual rights to bodily autonomy can be exercised without fear of prosecution at one of the most physically and mentally vulnerable points in any woman's life. I look forward to hearing the contributions of other members and the government, and we'll call it a day at that point.
Jim Shannon.
Mr. Chairman, thank you very
Apologies,
much.
Jim. I should have read out the petition first. First of all, can I remind members that they must bob if they want to catch my eye. The question is that this House has considered E-petition 70014 relating to decriminalising abortion. Now we can have Jim Shannon.
Mr. Chairman, thank you very much. It's not often I come to Westminster Hall and find myself the first person to be called after the proposer, in this case of the petition, but I'm very pleased to give my comments on where we are in the petition as well. I try in this world to try and be respectful to everyone. That's the nature of who I am and what I do. So I'd probably have a very, very different opinion from some of those, the honourable gentleman who spoke, for instance, on behalf of the petition, and others who may speak afterwards. It is one of the quirks of this place and our procedures that we find ourselves debating this petition today, when in all likelihood, Mr. Chairman, we will have a very similar debate in the next few weeks on new clauses tabled to the Crime and Policing Bill in the main chamber. So what we're doing today is almost a rehearsal for what's going to come potentially in a few weeks' time. I won't, you will pleased to hear, digress too much into discussion of the specifics of the amendments to be tabled in the Crime and Policing Bill. Safe to say that they are deeply concerning to me and many thousands of my constituents, for some of the reasons I will come on to. The honourable gentleman, I referred to where we are in Northern Ireland and our position, and those of my constituents and what they have made me very aware of. So what I'll be speaking today will be the position, my position, but also those of my constituents and many other constituents across the whole of Northern Ireland. I should say at the outset I find it tragically ironic that proposals have been made to further liberalise the law here, in part on the premise that the law is more liberal, more permissive and supposedly more progressive in Northern Ireland, whenever this is a place that was put forward as a suggestion. Of course, the change to the law on abortion in Northern Ireland was only brought about as a result of overreach, I use that word on purpose, by Westminster, undermining the constitutional value of Northern Ireland and its elected representatives, who should have been allowed to make decisions on this matter. And on a personal level, and on behalf of my constituents, it's important to place that on record in this debate here in Westminster Hall today. Honourable members will, of course, know by my position on abortion as a matter of public record. Indeed, I don't think in all my 14, coming to 15 years here, there hasn't been a question or a debate on this subject matter that I have not participated in or had a question in the chamber. That's for the record. So I'm not going to go into any much more detail. Safe to say that in my view, every abortion is a tragedy, both for the woman and also for the unborn child whose life is cut short. I hope that my view will be respected in this debate, as I respect those who hold a very different view of my own. And this is a very sensitive subject, Mr. Chairman, and deserves to be considered in that light. But it's also important that we consider this debate in the round as well. There is no right to abortion in international law. First, it is worth noting at the outset that, contrary to what seems to be a popular belief in both the media and indeed amongst some honourable members, even academics who take an opposing view to mine on abortion acknowledge that there is no right to abortion directly enshrined in any key international human rights instrument. That's their opinion. I put that on record as well, because it's important when we discuss these matters we have this in its fullness. Again, though it is often cited as the emphasis and imperative for change in the UK, the recommendations of the Committee on the Elimination of Discrimination against Women in this regard are not binding for the United Kingdom. We can and should determine our own laws on this subject, and it is neither required nor determined that we should go down this path of further liberalisation. Abortion is not, Mr. Chairman, simply medical treatment. This is not a simple matter. It's certainly not for me, it's not for my constituents, it's not for us who represent this point of view. Absolutely, yes.
Thank the Honourable Member for giving way, and he's making a very powerful point. In contrast, human rights laws grant protection to the unborn. The preamble to the UN Convention on the Rights of the Child, to which the UK is a signatory, states that the child needs special safeguards and care, including appropriate legal protection before as well as after birth. Would he agree with me that in every case both lives matter?
Yeah,
Jim Shannon.
That's exactly the point I'm saying. I thank my honourable friend and colleague for that intervention, and the honourable lady's mind is the same as my mind, and the same as the people that we represent across the province and also in our constituencies. Abortion is not simply a medical treatment. It's not a simple matter. It's one of the underlying rationales behind the push for decriminalisation of abortion. Is another point worth addressing as well. Abortion is not a mere medical treatment, which should therefore be treated akin to other matters of healthcare. However uncomfortable this may be to confront my view, and the biological reality is that there is more than one life involved in any abortion. It is essential that this is reflected in the law and in the penalties which result from breaking that law. Of course, laws send messages and shape culture very hard.
Give way. Thank you. I completely agree we need to be completely respectful in this debate, and people are going to hold views on all sides. But does he agree with me, as we've seen the examples in the US, that when you criminalise women and their bodies and abortions, you get absolutely mad circumstances where a woman cannot be saved in the emergency room and the A&E because it might facilitate losing that child, or she is kept alive against her family's wishes through machines just because she was 9 weeks pregnant at the time of her accident.
Jim Shannon.
Thank the Honourable Lady for her intervention. I understand the point the Honourable Lady is making, but in relation to where we are, I mentioned earlier on that every abortion there's two lives in it. There's a life of the mum, there's a life of the baby. The two lives have to be considered, and then we also have to be concerned about backstreet abortions and where that sometimes can lead us to as well. Of course, laws, as I said, send messages and they shape culture. More broadly still, the laws are a reflection of our core values as a society. And whilst calls for abortion decriminalisation are repeated and vocal, I truly think that many people don't, perhaps with great respect, understand the implications of what decriminalisation abortion means. The Honourable Lady will have an opinion. I have a very clear opinion. They may not be in the same level, they may not mean the same thing, but I certainly have one that would have a different interpretation of what the Honourable Lady refers to. Whether
Stella Creasy.
And I hope he knows that I've always respectfully disagreed with him on this matter and fought for his right to be heard. I do want to challenge him, though, on this idea that we can only have an opinion about what actual decriminalisation and indeed the human rights framework could look like, because since 2019 we have had that in Northern Ireland, and we now have a body of work by the Northern Ireland Human Rights Commissioner and court cases where she has intervened to uphold that human right and to uphold the implications of decriminalisation. We may differ about whether the impact of that is one that we would like to see in society, but we can't deny that there is now a body of evidence about what a human rights framework and approach to abortion access would look like.
Jim Shannon.
Thank you, Honourable, for that. Honourable and I have debated these at some length over the years from two different points of view in relation to it. I think the decriminalisation leads to deregulation, and we have some concerns where we end up. I said at the very beginning I want to represent the views of my constituents and those of other constituents. We've another three honourable members from Northern Ireland who have similar views to my own, again driven by their constituents, driven by their points of view, to respectfully give that point of view in this chamber here today in where we are. Whether it is by disapplying the provisions of existing penalties under sections 58 and 59 or section 60 of the Offences Against the Person Act 1861 and the Infant Life Preservation Act of 1929, or by repeating all of these provisions altogether, decriminalisation of abortion would be a seismic change. Seismic word is used on purpose, Mr Chairman, because that, I believe, reflects the size and the magnitude of what's been proposed. And to be clear, regardless of whether the specific provisions of the Abortion Act 1967 are touched upon by amendments to legislation, by gutting the laws which underpin the 1967 Act, the effect is the same. Again, depending on the model of decriminalisation, the effect would range from de facto access to abortion for women up to birth for any reason. There would be no enforceable prohibition on abortion on the basis of the sex of the unborn baby, for example, without criminal repercussion. Very happy to give way, yeah.
Alex Easton.
Thank the honourable member for giving way. Would the member agree with me that Britain already has very liberal abortion laws and is double the 12-week average in any other European Union country? And would he further agree with me that polling by Comres, which is a highly respected polling company, has shown 7% of women support a reduction in the abortion time limit, and 91% want an explicit ban on sex selection abortions?
Jim Shannon.
Thank you, my honourable friend and colleague who have been friends for many, many years in the Assembly, many moons ago, and did in the Council and today in Westminster. And I'm aware of the Comrades' comments and the polls that they have taken over a period of time, and they can't be ignored either, because they do give a focus to where we are. Without criminal repercussion, I refer to there being no restrictions whatsoever on abortions carried out by women or medical professionals up to birth. Are we truly ready, Mr Chairman, to take such a radical step? Not to labour the point, but I find it deeply troubling that a child born prematurely at, say, 22 or 24 weeks would be treated as a legal person with full rights, whilst at the same time decriminalisation would permit abortion at the same gestational age with no legal recourse. I said earlier, there's two people in this. There's the woman, the mother, and there's the baby. Ultimately, we are not...
Stella Creasy.
Under our current criminal legislation, abortions can take place. You can be exempted from prosecution up to 24 weeks, and in some instances further, there's an imminent threat of death to the mother or the child. What he's talking about are the 3,000 abortions that happen every year after somebody's had the worst news possible, a baby they much wanted, but they get the 20-week anomaly scan and they are told that that child will not make it past birth. I don't think the Honourable Gentleman is a cruel man. I don't think he wishes to advocate that women should be forced to carry children to term they know are going to die, but that is not affected by our current regulations. What he's putting at risk is access to that moment for women by advocating for a reduction in the time limit.
Again, obviously she and I will have a slightly different opinion in relation to it. It's about opening up the decriminalisation. It's about giving... I say this because it's something that concerned me over a period of time, still does, about the a Down syndrome child. And we've had examples of that with one in Northern Ireland, a lovely young Down syndrome child who wouldn't be here today, only that their parents decided that they wanted to ensure that that young girl would have the opportunity to have a life. So we're talking about those things. Ultimately, we're not talking necessarily solely about what is ethically or morally good or bad, right or wrong, but what would be permissible under the law without criminal sanction. And that is where I am, and where others will speak to it in the reality in law. Increasing in late-term unsafe abortions, decriminalisation sounds innocuous. But when the public is polled, and the Honourable Gentleman for North Down referred to it, when the public is polled and the effective results are plain, only 1% of the public support abortion being permitted up to birth, which is what decriminalisation abortion would permit. So very much against the majority, that'd be 99% of the people, without legal consequence. Honourable members may be interested to learn that following an Honourable Lady for Upper Bann referred to the decriminalisation of abortion in New Zealand in March 2020, late-term abortions, i.e. after 20 weeks gestation, increased by 43% compared to the previous year. This isn't scaremongering, Mr Chairman. This is evidential fact. And I say that for honourable members all to take on board the information that we're saying, and we're not asking anyone to ignore that. As the evidence from overseas shows, the risk of decriminalisation of abortion is not that more abortions may take place, but that the very thing which supposedly prompted the introduction of the Abortion Act 67 is England and Wales. Dangers, unsafe abortions will occur. And none of the legislative proposals to date, including the amendments tabled by the Crime and Policing Bill, are there safeguards which will effectively guard against women seeking abortions who are the subject of coercion or abuse. Nor is it clear to me, or indeed some of the rest of us here, given the operation of the pills by post system, there can be any guarantee that a woman's gestational age or her general health can be effectively ascertained under a decriminalisation regime. Whatever the view we take on the principle of abortion, I think there's a general public consensus that fewer abortions taking place is a good thing. So I am concerned, therefore, that decriminalisation of abortion will lead to normalisation of late or at least later-term abortions and have a chilling effect, Mr Chairman, on discussion around viability and the value of life more broadly. I'm coming to an end, Mr Chairman. I'm conscious, I know we have 3 hours or thereabouts, but others want to speak. By removing the deterrent effect of the criminal law, alongside the ready availability of pills by post without the requirement for an in-person consultation, which is really critical, I believe, for this, the bitter irony of decriminalisation abortion is that women will be placed at greater risk of harm. Not all choices should be entirely free or unfettered, and we accept limits to our choice in many areas of law. This should be no exception. The criminal law relating to abortion safeguards women by providing clarity and a regulatory framework. Decriminalisation does the opposite, but in a way which is much, much more damaging and much more critical to the debate that we're having. Decriminalisation is not a simple matter of choice and autonomy. If we reduce this debate to this, we will fail in our duty to protect women and to protect the babies. I urge honourable members again, irrespective of their view on the principle, which, as I said earlier, may be very, very different to the one that I have, to consider the full ramifications of decriminalisation of abortion. It will harm more than helping, and those who suffer will be women who endanger their own safety and will, as well, of course, as the unborn children, which are equally important. We must, I believe, protect both equally. Decriminalisation of abortion fails to accomplish this. Mr Chairman, thank you very much.
Thank
you, Mr Vickers. It's a pleasure to serve under your chairship, and I'd like to pay tribute to the member for Folkestone and Hythe for opening this very important petitions debate today. I'd like to also put on record my thanks to the petitioner, Gemma, and everyone who signed the petition. It is a real privilege to speak in this timely debate today. Abortion remains a criminal offence in England and Wales under a law written in 1861. That means that in those two jurisdictions, still in 2025, women can be criminally prosecuted and imprisoned for ending their own pregnancies. This is not a theoretical consequence of a law passed before women even had the right to vote. It is happening now at an increasing rate. Since 2020, around 100 women have been criminally investigated. 6 have faced court and 1 has been sent to prison on suspicion of illegal abortion offences. These investigations are dehumanising and prolonged, and the women forced to endure them are often extraordinarily vulnerable. Victims of domestic abuse and violence, human trafficking, sexual exploitation, and girls under the age of 18, as well as many women who have suffered miscarriage, stillbirth, or who have given birth prematurely. Victims but treated as suspects, Mr Vickers, subjected to invasive investigations that inflict profound long-term harm. Because of this law, women are being dragged through police cells after having given birth and being forced to wait up to 6 years for a court date. Mothers are being torn from their existing children and new babies, sometimes for years. Some of them are still fighting to get them back. Women have received death threats. They've self-harmed, been denied access to the mental and physical health care they require following their trauma, and forced to spend every single penny they and their families have earned just to defend themselves. Just what public interest is this serving? This is not justice, this is cruelty. And yet now, under new guidance from the National Police Chiefs Council, officers are being told they can seize women's phones, search her messages, her internet history, even her health apps, if she is suspected of ending a pregnancy outside the law. State-sanctioned surveillance of victims being treated like criminals. This is why the law got to change. It has to change. And this is why I have tabled amendment, new clause 1, to the Crime and Policing Bill, to put an end to the prosecution of women for ending their own pregnancies, with the backing of 115 cross-party MPs and 50 sector organisations. My amendment, Mr Vickers, simply disapplies the criminal law related to abortion from women acting in relation to her own pregnancy. Despite what those on the opposing side scaremonger, my amendment is narrow and targeted. It changes absolutely nothing about the provision of abortion services. The conditions laid out in the Abortion Act 1967, including time limit, the need to meet certain criteria and the need for approval of 2 doctors' signatures. Nothing. It maintains existing punishments for both medical professionals and violent partners who end a pregnancy outside the law. Instead, new clause 1 simply removes the threat of criminal liability for women who end their own pregnancies, enabling them to get the care and support that they need. It would, as has been mentioned, bring us into line with Northern Ireland, Ireland, France, Australia, New Zealand and Canada. The reality is that there is no woman that we accept 24 weeks pregnant or more and suddenly decides to end their own pregnancy outside a hospital or a clinic. But some women in desperate circumstances make choices many of us would struggle to understand. What they need is compassion and care, not the threat of criminal prosecution. Colleagues will be aware that the Honourable Member for Walthamstow has brought forward a different amendment in this regard to the Crime and Policing Bill, new clause 20. And while she and I share the same interest and the same overarching objective to remove women from the criminal law related to abortion, it is markedly broader in terms of the scope of change proposed to the long-standing settlement which provides for abortion services. This framework is complex. Hard-won battles have cemented women's access to abortion in this country into primary legislation, and Parliament has, up to now, remained resistant to changes that constitute a rollback. I do have concerns about overturning this entire framework at the current time and replacing it with a mechanism that would leave power in the hands of a single minister. And I'd like to know if the Minister agrees that such powers would mark a sea change in the long-standing underlying framework that provides for abortion in England and Wales. The Abortion Act 1967 is also related to the underlying criminal law related to abortion in England and Wales. Repealing this in its entirety brings the continued practical operation and enforcement of the Abortion Act into question. Can the Minister comment on the likelihood of this leaving a regulatory gap? We are lucky. We are lucky enough to live somewhere where abortion is accessible to the vast majority of women, and rightly so. We must ensure we preserve that, particularly given the current political climate in the world. I'd also expect for any proposed changes on this subject to be consulted on and have input from the sector, whose continued essential work is underpinned by the current settlement. I am staunchly pro-choice, and as much as I believe future reforms are needed regarding abortion provision, we must not lose sight of the current moral imperative here and its urgency, namely vulnerable women being dragged from hospital bed to police cell under suspicion of ending their own pregnancies. This can be stopped by disapplying the criminal law related to abortion from women. NC1 has the explicit backing of every single organisation that represents abortion providers in England and Wales. It is also supported by the Royal Colleges of Gynaecologists and Obstetricians, midwives, general practitioners, psychiatrists and nursing. Countless violence against women and girls groups, including the End the Vaughan Coalition, Refuge, Southall Black Sisters, Rape Crisis England and Wales, IMCAN and the Centre for Women's Justice are also behind New Clause 1. My amendment is also supported by today's petitioner, so thank you, Gemma. The public supports this change. This petition is signed by over 103,000 people. That is a stark reinforcement of that fact. And it is time, Mr Vickers, to ensure for those desperate women where the law or access to abortion fails them, they can safely turn to healthcare in their time of need, and often the worst moments out in their lives, without fear of being turned into the police by their own doctors. These women deserve the care and compassion that they need. We have spoken today of the case of Nicola Packer. There must be no more Nicola Packers. Thank you, Mr Chair.
Alex Brewer.
Thank you, Mr Vickers. It is a pleasure to serve with you in the chair, and I'd like to thank the Petitions Committee for selecting this timely topic for debate. From my experience running a women's refuge and serving on the Women and Equality Select Committee, I have seen how our criminal justice system disproportionately lets down vulnerable women. Since 2020, 100 women and girls have been investigated by police on suspicion of having illegal abortions. And very concerningly, this number is rising. Indeed, new guidance this year from the National Police Chiefs Council reminds police officers to search women's houses for drugs related to ending pregnancy, to seize their digital devices, to check internet search history, messages to friends and family, and even to access health data through their menstrual cycle and fertility tracking apps, subverting the very tools that are designed to keep us healthy. The guidance goes on to suggest how police officers could bypass the requirements of a court order to access NHS medical records. And who are these suspects that need such interrogation? They are often women who have suffered stillbirths, miscarriages and premature labours. Can we honestly say it is right for police to be targeting these women for criminal investigation at a point of such trauma? This is what happened to Sammy. After a traumatic birth, Sammy was resuscitating her newborn baby when 7 police officers arrived at her house ahead of any paramedics or medical staff. Her home became a crime scene and she became a suspect. The police raided her bins, suspecting that she had illegally taken abortion medication. her phone, computer and all communication with her partner blocked by police. She provided forensic samples that did not show the presence of abortion drugs, but despite this remained under police investigation for a year, during which time she was only allowed limited supervised contact with her baby. For those in this debate who emphasise the life of the child, what benefit does this separation from a mother bring to a newborn? Sammy's story is not an isolated incident. It is part of a disturbing pattern that is creating a culture of fear around women's reproductive rights. Sophie, a teenager, was arrested in the middle of the night following a police raid on her parents' home. She was held in custody for 19 hours. Despite her age and vulnerability, she faced 2 trials, and it took 6 years for the charge that she ended her own pregnancy to then be dropped. And Sophie is not the last. We have already heard the case of Nicola Parker. Yes, of course.
I want to thank the Honourable Member for such a powerful speech as he's making and reminding us about the mothers that are absolutely traumatised by this. Often they have other children from before who are also traumatised. The tactics being used by the police are increasingly worrying to me, and I wonder if she shares my worry that this escalation that we've seen in these last few years seems to mirror the escalation that we've seen in the US, and that we don't want to be in a position like the United States where women are literally dying because healthcare professionals are worried about intervening because they could lose their licence and be put in jail.
Alex Brewer.
I thank the Honourable Member for her intervention, and I absolutely agree that is a fear I share. Nicola went to hospital with the purpose of seeking care, but instead was passed to the police. She was charged with carrying out an illegal abortion, a nightmare that lasted 4.5 years before she was acquitted unanimously by a jury. These incidents do in fact reflect a system that increasingly criminalises women for seeking healthcare, and we cannot let it continue. To overcome the fear and anxiety many women face when seeking medical support, we must instead build a society rooted in compassion and centred on safe, supportive healthcare, where abortion care and after-birth care are recognised as vital parts of women's health services. I will give way.
I thank the Honourable Member for giving way, and she references Nicola Parker. Would she not say that the solution to this case is not decriminalisation, it's actually to reinstate the gestational age checks by the pills by post, which was refused by this Parliament?
I thank the Honourable Member for her intervention, but no, I don't agree. To overcome fear and anxiety many women face when seeking medical support, we must build a society rooted in compassion and centred on safe, supportive healthcare, where all of this healthcare is treated as part of a women's services, not with suspicion or stigma. One route to decriminalise abortion is through New Clause 1, an amendment tabled to the Crime and Policing Bill. New Clause 1 would bring England and Wales in line with Northern Ireland and countries like France, Ireland, Canada and Australia, where women are not criminalised for abortion. The amendment is backed by End Violence Against Women, by Refuge, Rape Crisis England and Wales and many others. It does not change time limits or legal safeguards, it simply removes the threat of prosecution for women. 88% of abortions in England and Wales occur before 10 weeks. The idea that decriminalisation would lead to many more late-term abortions is simply not supported by evidence. At a time when reproductive rights are under threat globally, we must act. Decriminalising abortion is a necessary step towards equality, compassion and justice.
Hassan.
Thank you, Chair, and it's a pleasure to serve under your chairship. As mentioned, abortion is currently a criminal offence in England and Wales under the 1861 Offences Against the Persons Act, and unless certain conditions are met, we have the harshest punishment in the world for illegal abortion, life imprisonment. This, despite the fact that the UK is an overwhelmingly pro-choice nation, with a recent YouGov poll showing that 87% of the British public say abortion should be allowed in the UK, compared to just 6% who said it should not. Much like this overwhelming majority of the country, I fully support a woman's right to choose. And as a frontline healthcare worker for 20 years, I can say with experience and conviction that access to safe and legal abortion is a fundamental aspect of any modern healthcare system. It is crucial that women and girls around the country have access to safe, high-quality healthcare that supports their well-being, and this must include women's sexual and reproductive healthcare. That is why I was proud to sign my name to the member for Gower's new Clause 1 to the Crime and Policing Bill, which would decriminalise abortion and ensure no woman should ever be prosecuted for ending her own pregnancy within the widely agreed upon 24-week window. With over 90 MPs from 8 parties now in support, I am confident that we'll finally right this historic wrong and stop the infringement upon women's rights. This issue has been debated far too long. It's an outrage that we've made such limited progress on updating a law passed 164 years ago, despite the immense societal change that we've undergone in that time. While the last Parliament made some limited progress on this issue, in particular by legislating for a safe access zone around abortion clinics and hospitals, they failed to legislate what so many are clearly crying out for, and that will forever be a stain on their record. Let us not repeat their mistake. Let us make progress and finally bring this injustice to an end.
Anne Davis.
Mr Vickers, and it's a pleasure to serve under your chairmanship. Statistics show that 1 in 3 women in the UK will have an abortion at some point in their lives, and the vast majority, as already has been said, is under 10 weeks gestation. But while the Abortion Act of 1967 makes abortion legal under strict conditions, it remains a criminal act under a law dating back over 160 years. And life is very different now to when the Offences Against the Person Act was introduced in 1861. However, a growing number of women are being investigated today for suspected illegal abortion under that Victorian law. In fact, at least 100 women and girls have been investigated on suspicion of having an illegal abortion over the past 5 years. Under updated police guidance, those investigations for sudden pregnancy loss can include searching a women's homes, checking phones and search history, and accessing NHS records without a court order, leaving many women treated like a suspect during a traumatising and likely devastating time, and all this happening while also physically recovering from that loss. And whilst this is going on, the loss of a baby, some have even been put on trial to face significant jail sentences. Women should not face criminalisation for acting on their right to receive reproductive health care and seeking medical help. And what does this mean? Changing the law does not mean agreeing with the actions of an individual woman, and I say that as a mamgi, as a granny of neonatal babies. It does not mean agreeing with the actions of women, but it does mean recognising that criminalisation is not the best way to ensure women have access to the care and support that they need. And this is far from unprecedented. Women are already exempt from the criminal law on abortion in Northern Ireland and in countries including France, Ireland, Canada and Australia. And it is also recommended by the World Health Organization. I commend my constituency neighbour, the Honourable Member of Vaughan, for her amendment to the Crime and Policing Bill to remove women from the criminal law for abortion, which is supported by 50 medical bodies, charities and women's organisations. Removing the threat of criminal liability for women who end their pregnancies would allow them to get the care and support that they need. As the law stands, the criminalisation of abortion impacts not just the women seeking abortion, but women suffering miscarriages, the trauma of stillbirths, and in effect, all pregnant women. Access to healthcare is right. It's high time to make that a reality for women without the threat of criminalisation. 164 years. It's amazing, isn't it? 164 years is long enough. Over 100,000 members of the public have signed this e-petition calling for the abortion to be decriminalised. It's time for the UK government to listen and to act.
Always the other way around. Thank you, Mr Vickers. It is a pleasure to serve under your chairmanship this afternoon in what is a very important debate for many of us who've been involved in this issue and in campaigning on it for many years, because we feel passionately that the equal ability to control what happens to your body is at the foundation of equality within society. So let me thank Gemma for her petition. Let me thank the member for Folkestone and Hythe for setting out so well the law. And let me call for us to be honest with the British public about what we are talking about, and therefore what, if they want to see decriminalise happen, it is decriminalisation. Because as the person who was the architect of the legislation in Northern Ireland, I want to be very clear what we did in Northern Ireland, and therefore the difference between that and the two proposals before us in the coming weeks in Parliament. In Northern Ireland, we did not do what New Clause 1 seeks to do, because New Clause 1 is not decriminalisation. It is disapplying the law from some people around abortion, but it retains abortion legislation. And for anybody who supports decriminalisation, we need to be clear that decriminalisation must mean repeal. That is what we did in Northern Ireland. That is why we have been able to protect women who previously had no access at all to any abortion provision. I'll happily give way, but then I do want to continue on.
Just on the issue that she raises about Northern Ireland, whatever about our different positions, and we accept there are fundamental differences here, but she did introduce what she did in relation to Northern Ireland, but does she accept that the views in Northern Ireland are quite distinct and different from the views in Walthamstow, both in the general public and amongst the representatives, the public representatives of those people?
The honourable gentleman asked you about the view of people in Northern Ireland. As my colleague from Folkestone has pointed out, in the 6 now years since that law was passed, and I do believe that human rights are universal, which is why I thought it was right for us in the United Kingdom Parliament to seek to act for all those women in Northern Ireland whose rights were being denied by the previous status quo. But there has been no call to reverse the provisions that we've made in Northern Ireland. There has been resistance, and I want to go on to talk about that resistance and why, therefore, we can learn from that resistance in tabling New Clause 20. But I want to be very clear. Anybody who claims that they are supporting decriminalisation by supporting New Clause 1 is not telling you what really decriminalisation looks like. Decriminalisation must involve repeal. That is why New Clause 20 repeals the legislation around abortion. And that matters because we have seen already, under the existing framework here, this police guidance talking about prosecuting women. I agree with the member for Gower. None of us want to see the prosecutions. Many of us have been very concerned for some years now about the increase in investigation and prosecution of women for abortion. We've not really been able to bottom out why there has been such a surge in this, or why they felt the need to produce this guidance. Nothing in New Clause 1 would stop subsequent guidance being issued that targeted the partners of those people who have an abortion, that targeted the medics who provided those abortions, that demanded women gave evidence as part of that process. If we want to finally put to bed the notion that in this country abortion is treated in the same way as the safety of railway workers and the possession of explosives, which it is in the Offences Against the Person Act, then we have to remove these offences from the legislation. In doing so, as New Clause 20 does, it explicitly says there can be no investigation or prosecution under those offences, and therefore it would offer protection to all those people involved in making sure that women can access safe and legal abortions. And that is why we took that approach in Northern Ireland, because in Northern Ireland there was no abortion service at all, but what we wanted to do was to fight for what should be an abortion service. And that's my second point today, because actually if we want to protect access to abortion, and I think those of us who would consider ourselves pro-choice would say, absolutely, we want to stop the investigations and the prosecutions, but we also recognise, as members opposite have set out many of those arguments that are made to attack abortion access in this country, then that is where that human rights legislation came in. Because it's not true that when we passed the legislation in Northern Ireland in 2019, there was immediately access to abortion. We had to fight tooth and nail against those people who used their positions to thwart that legislation. And the reason that we were able to do that was because we had written into law a human rights lock. And that meant that whether there were people who were in the civil service, in the police, in the healthcare service, who did not approve of abortion and sought to resist that legislation, the Secretary of State had to stand up for the right of women in Northern Ireland to access a safe and legal abortion. I sat with the Secretaries of State at that point, who were not themselves particularly supportive of abortion access, as they admitted to me that they had to push through that legislation. They had to make sure that provision was happening. I have read the judgments from the courts where the Human Rights Commissioner of Northern Ireland has intervened directly using those powers that we wrote into law to defend access to abortion. Why does that matter? Because we know that abortion is already under attack in this country. Now, I know many people are concerned about the Americanization of our debate here, and I want to come on to that. But we've already seen millions of pounds being spent on anti-abortion activism in this country. We don't need to import those people from America. We have people like Lord Michael Hintz and Lord Michael Farmer who are more than happy to fund anti-abortion activism. And I pay tribute to the work of Dr. Pam Lowe in identifying and tracking this. What does that mean? Well, first of all, it means that we can see there's been better coordination of the anti-abortion campaigning against not just decriminalisation, but the arguments that are made about the time limit, the arguments that are made about telemedicine, indeed the arguments that are made ultimately because we're demanding to know why women wish to have an abortion, which we do with no other healthcare provision. With no other healthcare permission do we demand that women explain themselves and justify themselves before we provide it. Whether it is the March for Life, the activities on our campuses, or indeed the lobbying of MPs. Anybody who is complacent before we saw the Trump playbook being brought into British politics about access to abortion in this country needs to look more closely at what has been happening. So when we legislate about abortion, we don't just need to properly decriminalise, we need to properly protect. And that's why we have tabled New Clause 20, which has cross-party support. Because if you don't ask for abolition, what the anti-abortion movement does is they never ask for abolition, they ask for more safeguards. They ask for more visits to doctors to delay the process of accessing an abortion. They make a claim about medical technology. Of course, it is amazing when doctors are able to do wonderful things to save the lives of children born prematurely. But this is apples and pears. The people who have to choose to make that horrible choice to have a late-term abortion are not doing so with the best of news in their hearts, but with the hearts that are broken, because they have been told that their child will not live past birth. Who are we, as a society here in England and Wales, to compel those women to keep carrying a child to term that they know will die in a way that we do not do now in Northern Ireland? I'll happily give way.
I think the mask is serving today, and this is more of an attack on those who seek to go and lobby and promote the protection of life in this United Kingdom. And I, for one, want to stand up for those people today. I think that's such an insult towards the many groups and many organisations who value life and who value both lives in every pregnancy. And I think it's outrageous that those people have been demonised in that way today.
Stella Creasy.
I'm sorry that the member opposite feels like that. I hope she heard my words to her colleague. I have always, and it's been on the record, defended the right of people who disagree with abortion to make their argument. I have always, the member is chuntering from a sedentary position, I have always defended the right of people to disagree. What I don't do is defend the right of people who disagree to harass. So let me talk exactly about another example of where abortion access is under threat. We fought tooth and nail under the previous Parliament to get safe access zones to abortion clinics into place because we absolutely uphold people's religious liberties. But you do not have a religious right to pray anywhere that you like that trumps the privacy, the human right of privacy that a woman has when she's made the choice to have an abortion to go to a clinic. And my colleague from Bournemouth set out what the consequences of that has been. Nothing in New Clause 1 would protect buffer zones. New Clause 20 would explicitly protect buffer zones because in Northern Ireland, the Human Rights Commissioner has intervened to protect buffer zones as part of human rights legislation. Now, some may argue, don't worry, because she made that ruling, because she fought that case for us in Northern Ireland, we can apply it to England and Wales. New Clause 20 would put that beyond doubt. So tabling New Clause 20 is not about some untried and untested mechanism for defending abortion. It is about recognising we have to repeal the legislation before us, and then we have to say what happens next if we actually want to protect abortion access. I will, of course, give way. He gave way to me.
Jim Shannon.
Unbelievable. I think I have to put it on record. I can't let the occasion pass without not making comment on it, Mr. Chairman. And that's in relation to those who have silent prayer. A silent prayer is very much that. It's a silent prayer between the person, the individual, and their God, which they make in that. And there's nothing verbally ever said in relation to it. And for someone with respect to that ability to say that a silent prayer is wrong, I don't believe that. I think it's totally erroneous to make forward that comment, and I have to put that on record. Thank you.
Stella Creasy.
I understand the position he's making. There are many of us who believe that somebody standing at an abortion clinic and feeling the need that they have to pray there, rather than in a church or 150 metres away from an abortion clinic, is not silently praying and is intervening on the privacy of the person accessing an abortion zone. That is why this Parliament, I hear gentlemen chuntering, I want to make some progress on this, but let me be very clear. Those of us who recognise that it balances rights in the best way, that we have safe access zones, recognise that he is not alone in continuing to attack them. The Vice President of America has sought to attack our ability as a nation to protect women's access to abortion clinics via safe access zones. So it is not a theoretical threat that we are facing.
Emily Darlington.
So I'm thank my honourable member for giving my honourable friend for giving way, and she's making a very powerful speech as well as all the speeches that have been made today. I have never had an abortion, and I'm lucky not to, but I've had 2 miscarriages, and I cannot tell you how vulnerable I was at that time. And anybody coming up to me at that point would have made me feel even more terrible than I already did. Now, I believe, and I have friends who have had abortions, it is a terrible choice to make it for whatever reason you are making it, whether that child wouldn't survive or that is a child of rape, or for whatever reason that choice get made. Nobody makes that choice happily. Does she agree with me that the reason there are exclusion zones is because the human rights of that woman who is going through one of the worst times of her life, her rights must be protected at the time of such a horrible time in her own life?
Stella Creasy.
I pay tribute to the personal testimony that she has given. And what she's touching on is what has been happening in this debate for several years now in this country, which is the expectation that we should be given a reason why women want to have an abortion or why women seek that kind of medical care. And that is where the Trump playbook being brought into British politics, as we now see that it is being, is so dangerous in this context. Because when the leader of Reform, and I note that he's not here today to defend his views, talks about the ludicrous nature of our laws and calls for reduction in time limit, I don't actually think he's thinking about all those people who get that horrific diagnosis. What he's doing is sending a bat signal to his colleagues and his fellow travellers in America that this country, under his watch, would be open season.
Order. Can I remind the Honourable Lady, if she's referring to another member, she should have given that member advance warning.
I do apologise, Mr Vickers. I just thought, given the recent pronouncement, the honourable member would be here today, given that he's shown such an interest in this matter. But let me talk then about the Vice President of America, because I hope you will understand that I probably couldn't ask him to be here today, who is one of those fellow travellers who believes that there are votes to be gained by using women's bodies as a battlefield, because that's what the debate about abortion in America has become. What we are seeing is American ideals, this concept of abortion at birth, this idea that women should be expected to explain themselves being brought into our debates here. And I ask my colleagues across the House, I know many of us will fight tooth and nail against those narratives. Many of us will fight tooth and nail for equality. Do we want to have the power of a human rights commissioner backing us up in those fights when people come for our abortion rights, when people propose further restrictions, further safeguards to abortion? Because this is our chance to do that. New Clause 20 learns from a body of law and a body of practice in Northern Ireland about how we properly protect abortion. We don't just decriminalise it, actually decriminalise it, it properly protects abortion. And I listened to the member for Gower. I urge her to reread New Clause 20, because from what she said, I don't think she has properly. Rather than concentrating power in the hands of ministers, precisely because of the risk that comes from any future government that may seek to use secondary legislation powers, it actively restricts them. It has a triple lock. It says that regulations can only be made to uphold that human rights approach. And then it says they cannot be used to reduce access to abortion or to amend Section 1 of the 1967 Act, which New Clause 20 keeps in play as a list for regulation rather than prosecution. So it does not touch the time limits either. And then it says that any attempt to undermine that human rights lock could only be done with the support of the entire Parliament. Now, anybody here who's a new Member of Parliament, probably in the last year, has had the pleasure of sitting on a delegated legislation committee and wondering quite what you're doing in a small committee room. You are making law, but you're making law in a committee where the balance of power has been determined by the whips, where the government gets to decide who sits on that committee. Those are secondary legislation powers. It is entirely conceivable that New Clause 1, if it is passed, gives those secondary legislation powers, because they are in the policing bill, to a future government without any restriction. I'll happily give way.
Thank you. And I thank the honourable member for giving way, because I think it's interesting that New Clause 1, it's not a competition between myself and her either, but because we both have the same aim here. But also, I think, you know, the fact that over 115 MPs have signed this, and also all of the industry, you know, everybody has signed it. Has she had conversations with them to see why they haven't signed hers?
Stella Creasy.
I'm sorry that the member for Gower feels the need to ask that question, because she will know full well that despite me asking repeatedly to meet with her and repeatedly to talk to the campaigners that she's been working with, that meeting hasn't yet been forthcoming. I'm still open to meeting with people, but I think we need to be very clear on the record. This amendment has in it a lock on the activity of ministers, deliberately so, because this is a human rights issue. It should be a matter that is subject to the entire Parliament. And it should be very clear that ministers could only ever use the powers in this legislation to make human rights compliant legislation. If they did not, the Human Rights Commissioner could challenge them on it and take the Secretary of State to court, just as they have in Northern Ireland. By converse, New Clause 1 allows ministers secondary legislation powers without any restrictions. So I ask again members who are concerned about ministers being involved in writing legislation to look at the difference when it comes to that constitutional role, because I recognise that only you've had the pleasure of repeated secondary legislation committees will you understand the powers that they can have. Certainly I would encourage people to look at how George Osborne used secondary legislation powers to change the student tuition fee rates, to change benefit rights. The previous government used them on the retained EU law legislation. The scope of them has been broadening. Many of us respect the role of government, but obviously we recognise that should there be a government that has a more extreme agenda in the future, it will also have those powers. This amendment, New Clause 20, locks those powers down. Mr Vickers, I do not wish to delay the committee any longer, because I know there are others who wish to speak. And actually what really matters is that we're clear about why proper decriminalisation matters, because restricting access to abortion does not stop abortion, it stops safe abortion. Failing to protect access to abortion does not make it easier for people to have children. It simply means there is more pain, more misery, more heartache to be had. There is no right amount of abortions to happen in our society. There is a basic human right at stake here. And members in this House who are alive to the politics and the policy debates around abortion and around politics would do well to think about how they will feel in 5 years' time if what we are seeing at the moment is the start, not the end, of assaults on abortion. I urge members who care about decriminalisation to back New Clause 20 and make sure that we actually have the human right they have in France, in Northern Ireland, for our constituents as well in England and Wales.
Thank you, Mr. Chairman, and thank you to all those who have contributed to the debate today. And I'll obviously differ from many that have spoken and would like to concur very much with my colleague from Strangford, who outlined our case extremely well. For me, this is a debate on life, and I believe that both lives matter in every pregnancy. The most basic human right is the right to life. And I do speak today with deep, deep conviction on this issue and a desire to restore life-affirming laws to this entire United Kingdom, laws that protect the most vulnerable in our society. And I think it's important at the very start of my contribution to outline that since the 1967 Act was brought into force in the United Kingdom, 10 million abortions have taken place. One baby is lost to abortion every 2.5 minutes. 26 lives every hour, and this debate will last 3 hours. This is stark. So I come at it from a life perspective and the protection of life. And in every pregnancy, both lives matter. There are times in politics when one doesn't enjoy being right. Back in 2021, I wrote in the House magazine of my fears that the pills by post scheme for at-home abortions was leading and would lead to an increase in medical complications, dangerous late abortions and coerced abortions. Plenty of others expressed similar fears. Sadly, these fears have all proven to be true. A study based on Freedom of Information requests to NHS trusts found that more than 10,000 women who took at least one abortion pill at home provided by the NHS in 2020 needed hospital treatment for side effects, equivalent to more than 1 in 17 women or 20 women per day. Late last year, Stuart Warby was convicted of using abortion pills obtained by a third party through the Pills by Post scheme to induce an abortion of a woman against her knowledge or will. All of these could have been prevented if abortion providers had not lobbied in the face of warnings about precisely these kinds of incidents occurring, for the removal of in-person appointments where health risks could be assessed and the woman's identity and gestational age accurately verified. It is this last point of ensuring that a woman's gestational age is accurately verified that has indirectly led to the debate we are having today. The abortion lobby itself has acknowledged, and I quote Jonathan Lord, former medical director for abortion provider Mary Stopes, that until recently only 3 women had ever been on trial over the past 160 years for illegal abortions. Since then, there has been an increase in investigations and prosecutions, albeit still a very small number in light of the more than 250,000 abortions we now have every year in the United Kingdom, a national tragedy. So why has there been this small rise in prosecutions? Well, it is surely not because the CPS or police have suddenly decided to handle this issue in a more draconian way. Rather, the Pills by Post scheme has enabled women either dishonestly or because they've miscalculated their own gestational age to obtain abortion pills beyond the 10-week limit when at-home abortions are legal and considered safe for women. They are, of course, never safe for the baby, and even beyond the 24-week upper time limit for abortions in this country. Tragically, this has led to viable babies' lives being ended. The responsibility for this surely lies with those who lobbied for the pills by post scheme. So what is the solution? Well, it cannot be to make matters worse by decriminalising abortion. This would be highly irresponsible, creating conditions where a woman could perform her own abortion unsupervised without any legal deterrent away from a clinical setting at a stage in pregnancy when doing so would carry great risks and when her baby would be viable. De facto, we would be introducing abortion up to birth and reintroducing dangerous backstreet abortions. This is not pro-women, and it renders the time limit redundant in a context where pills can be obtained without any reliable in-person gestational age check. There is a clear alternative solution here to end the pills by post scheme and reinstate in-person consultations. Polling published by The Telegraph last year found that more than half of the public agreed that it should remain the case that a woman is breaking the law if she has an abortion of a healthy baby after the current 24-week legal time limit up until birth. Only 16% disagreed. The public does not support decriminalisation. Only 1% support abortion up to birth, which such proposals would introduce by the removal of offences prohibiting women from performing their own abortion at any stage. Polling has found that 71% of women support a return to in-person appointments, with only 9% in favour of continuing with the scheme. Decriminalisation is a convenient way to cover up the disastrous consequences of the pills by post scheme. I greatly fear that, just as my earlier warnings about this scheme have sadly proven true, if decriminalisation were introduced, my warnings today will also come true. More women will take abortion pills away from clinical context late in pregnancy, endangering their lives and leading to the tragic deaths of viable unborn babies. Permitting this would be profoundly irresponsible. Ideology would be trumping women's safety. One final comment. I have rarely witnessed anything as cynical and disingenuous as the argument put forward by supporters of decriminalisation that it would allow women in England and Wales to have the same so-called rights as women in Northern Ireland. When the member for Walthamstow hijacked the Northern Ireland Executive Formation Act to impose abortion in Northern Ireland without democratic consent, she seemed to have no problem at all with the law in England and Wales, bemoaning how women in Northern Ireland were being discriminated against because they did not have access to this same law. She then, however, helped introduce an even more extreme law for Northern Ireland than what we have here in England and Wales, and now cynically uses that more extreme law to argue that it is women in England and Wales who are now being discriminated against, despite the fact they can access abortions up to almost 6 months in pregnancy, essentially on demand. This is politics, in my mind, of the lowest kind. Of course, what is not often recognised is that introducing decriminalisation here would not bring abortion practice in England and Wales into line with Northern Ireland, because of the key differences that there is no pills by post scheme in Northern Ireland. It is the combination of the pills by post scheme, whereby women can obtain abortion pills without reliable checks for gestational age, health risks or coercion, while also removing any deterrent against women performing their own abortions right up to birth, that would make decriminalisation so dangerous and so irresponsible for this government. I hope my warnings will not go unheeded this time. Thank you.
And I'm most grateful to serve under your chairmanship. I'd like to thank the Petitions Committee for this crucial debate, and also like to thank Gemma and the thousands of people who have signed this petition, and the hundreds of constituents who have contacted me over the years, adding their voice to the call to end the archaic law that would see women accessing medical services given some of the harshest sentences our criminal system doles out. Despite the surrounding issues, we have to be clear that the debate today is is not specifically about changing the laws around termination limits. It's not about changing the eligibility for legal abortions, nor is it about changing the requirements for administering abortions. This is about changing antiquated laws from a bygone era that are no longer fit for our modern understanding of women's bodily autonomy or women's health. The Abortion Act, 1967, is now almost 60 years old. There are many things that have changed in terms of women's rights. In fact, it wasn't until 1992 that it was the idea that women could be raped by their husbands was criminalised. This near 60-year-old law is in urgent need of updating so that it protects women and our right to bodily autonomy rather than seeking to control it. Some of the other legislation that criminalises women for accessing healthcare dates to as early as the 1600s. In 2020, I was pleased to join parliamentarians in voting to repeal legislation in Northern Ireland that prosecuted women for terminating their own pregnancy. Yet in England, Scotland and Wales, this type of legislation remains in place. The rest of the UK is dragging so far behind the rest of the world that in England and Wales we have the harshest criminalisation of abortion than any other country in the world, and this includes countries that are actively anti-abortion, such as Poland and the USA. In fact, when President Trump announced his plans to criminalise women accessing abortion, he faced backlash from the Susan B. Anthony list, ardent anti-abortion campaigners. And in the past 3 years in England, 6 women have appeared in court charged with ending or attempting to end their own pregnancy. And abortion providers estimate that for every woman who ends up in court, at least 10 others are subject to prolonged police investigations. When we're talking about the women being criminalised, we're not just talking about women who have accessed abortions beyond the legal term limit, or even those who have been suspected of doing so. It's also about women who have experienced miscarriages and stillbirths. These women are being criminalised, investigated, and treated like criminals when they are going through a difficult and traumatic experience. As someone who has experienced a stillbirth myself, I can't express to you how traumatic it is, and the idea that this most difficult time, which can be the most difficult time in your lives, that you be treated in this way, it just bears no understanding whatsoever. And I remember that at a point very late on in my pregnancy, I was strongly advised, in fact, I felt under pressure to terminate my pregnancy. By doctors, not by anybody else. I was told that an injection could be given that would stop my baby's heart, and I would still have to give birth because of how late on this was. Now, I said no, and what I want to point out here is that it was my choice. It's very important to stress that it was my choice. We spend so much time fighting for abortion rights and that right to healthcare that we have no time to make the point that this is all about a choice that women are given. And so many come at this from a point of faith, and you need to understand that the right to exercise your faith in healthcare is a human right. And if you take one right away and you relinquish it for one group of women who may choose to act for whatever reason, you relinquish it from those women who may choose not to move forward with an abortion. And I think that we have to keep stressing that. It is about a choice. As women, and as a black woman, in fact, things have been done to our bodies as women over years for which we gave no consent. And these rights that we have now are about our autonomy, and we have to maintain them in whatever way that we can. Now, it can't be right that whilst a woman is in this situation, that the National Police Chief Council's recent guidance includes instructions to search women's homes, their internet history, text messages, and even their fertility tracking apps. This is awful, and the guidance also alarmingly outlines ways in which the police can obtain abortion-related medical records from NHS providers like MSI UK without a court order. Pregnancy loss is a devastating tragedy, and those who endure it deserve compassion and support, not criminalisation. It's grossly unacceptable to treat grieving parents as potential subjects in the loss of their child, and this guidance risks compounding grief with the fear of prosecution, creating an effect that could deter women from seeking medical help or honest conversations with healthcare providers. Equally, the decision to end a pregnancy can be devastating and a tragedy, and those who endure it deserve also compassion and support, not criminalisation. Access to healthcare should never be a criminal matter. Making it so only puts lives at risk. Rather than targeting bereaved families, there should be a focus on improving maternal healthcare, addressing systemic failures and ensuring that every parent receives the support they need during such a loss. As Louise McCudden, the head of the External Affairs at MSI UK, said, the guidance will be fueling a culture of hostility and suspicion towards not just abortion, but pregnancy loss. This policy is born out of a culture that demonises and criminalises women who access their abortions using their bodily autonomy, and it's sweeping up women who have seen their pregnancy come to an unplanned end. No one deserves to be investigated for ending their own pregnancy, and they certainly do not deserve it when they have lost their child. These women and their partners need support during this time, but they won't get it if they're being treated like criminals. The continued criminalisation of abortion is antiquated, it lacks compassion, and it needs to come to an end. And again, it is about a choice, and every woman should be allowed to make the choice based on her views and her beliefs. That is what our human rights are supposed to be about. Thank you.
Christine Jardine, Liberal Democrat spokesperson.
Thank you very much. It's an honour to serve with you and the Chair, Mr Dowd, and I also would like to thank the member for Folkestone and Hythe for his powerful introduction to this petition debate. It's very tenuous petition debate, but I would like to start first of all by saying that this is a conscience issue, and my Liberal Democrat colleagues may have very different views, but I find it ironic that it's a conscience issue over whether women should have a choice over their own reproductive health care. If you look at the petition itself, it calls on the UK government to remove abortion from criminal law so that no pregnant person can be criminalised for procuring their own abortion. That the UK is out of step with the World Health Organization, who recommended that barriers to abortion, such as criminalisation or approval of others on institutions, should be removed. And Amnesty International state that abortion is a human rights issue. I wonder actually how many people watching this debate or at home this evening are surprised that we still need to have this debate. They're astonished that women in this country can be criminalised for having an abortion because they believe that in 1967 the Abortion Act made abortion legal. Actually what it did was made it legal in certain circumstances. And we are still debating, more than half a century later, when it's appropriate, how it's appropriate, when women can have the choice. And as my honourable member said, so much has changed in those intervening years. So much about our society, about our laws, about the political situation in which we live today is different from when that law was passed in 1967. So what I would say is that I believe that everyone, regardless of their gender identity, has a right to make independent decisions over their reproductive health without interference by the state or the law. Access to reproductive health care is a human right, as has been confirmed by the Supreme Court in relation to Northern Ireland. So why are we debating it today? Because what we are seeing in this country is a rise in the number of prosecutions of women who have had abortions. And we're hearing the tactics that was spoken about in her powerful speech by the honourable member from North East Hampshire. The stories of women like Sammy and Sophie who are going through a trauma because they went through a trauma. They made a decision. And that, to me, is wholly unacceptable. But I also find it unfortunate that we are arguing today at times about how we decriminalise abortion, how we remove it from the statute books. Surely the thing to do is to remove it altogether, not make it partially removed or decriminalised. Remove it altogether. And the way we do that is by making it a human right, by making it a human right in the way it is in other countries. And I would also take issue with those who say that it's not a human right for women who have to go through an abortion, often against what their choice would be in other circumstances, often because they've been raped or because they've told that it's, you know, a medical necessity. They deserve the protection and the right of being able to go through that in private. It should be a completely private, personal choice and decision. And my honourable member spoke about the right of women to decide not to have an abortion. Of course, that is as important to me as the right to have an abortion. I don't know, I've said this so often in this place, I don't know what I would do in that situation. I have never had to make that choice. But I do not have the right to make that choice for any other woman. She has the right to make that choice based on her faith or her beliefs or her medical situation and her personal situation, without any interference from me or anybody else for that matter. So, briefly, frankly, I find the fact that we are still debating this a failure of our system to recognise the rights of every individual to their own healthcare decisions. And I believe that the only way that we can effectively do that, we can protect them from being criminalised, is to make it a human right in the way that we did in Northern Ireland. I was part, along with the honourable member of Walthamstow, of that campaign. And I think it is right that women in every part of the United Kingdom have the same protection, the same choice and the same rights. Thank you.
Spokesperson Kieran Mullen.
Thank you, Mr Dowden. It's a pleasure to serve under your chairmanship. And I also want to thank the Petitions Committee for enabling this debate and the Honourable Member for North Ayrshire and Arran for opening it. As a Shadow Justice Minister, I've spoken on behalf of His Majesty's opposition in recent debates on assisted dying, and I do so again today on another complex issue that similarly draws on ethical, legal and moral questions. I don't think today's debate is a failure. I think it reflects the complexity of the issue at hand. Like assisted dying, calls to decriminalise abortion can trigger profound disagreement between families, friends and indeed members of Parliament of the same and different political parties. I deeply respect the perspectives of those advocating for this change, including everyone who signed the petition, including the 142 constituents of mine in Bexhill and Battle. And I don't know the new members quite as well, but members, for example, the member for Gower, who I've come to respect very deeply in very many issues, even if we don't see eye to eye on this. And if there were to be a vote, the historical position has always been that there would be a free vote. There'll be a variety of views amongst Conservative MPs, councillors and members, and His Majesty's opposition would remain neutral. But it's fair to say that in my experience the preponderance of Conservative thought, particularly amongst parliamentarians, has been to be cautious about decriminalisation because it's argued that it carries risks that could undermine the current balance of rights and protections enshrined in our legal framework. Let me be absolutely clear to people watching, especially women who might be worried that the UK is somehow rowing back on our abortion provision. In England, Scotland and Wales, abortion is lawful, provided the usual criteria in the Abortion Act 1967 are met. There are different criteria in Northern Ireland, but the previous government did introduce a new legal framework for abortion services in Northern Ireland to that effect. As members have said, the Abortion Act 1967 provides grounds for an abortion, exempting women from prosecution under the Defences Against the Person Act and the Infant Life Act. The petitioners have asked us to consider whether abortion should be decriminalised completely so that no women, or potentially an individual who assists her, can be prosecuted for an abortion under any circumstances. But of course, when considering abortion, we are not just considering the well-being and autonomy and rights of the pregnant woman. Our society and legal system has also given consideration to the welfare of the unborn child. The phrase unborn child is on the face of it a clear and simple one, but of course in moral and legal terms, for most of it, it lacks the moral clarity we feel about the moral considerations due a child after its birth. Religious thought of all kinds very often ascribes moral rights of a high magnitude to an unborn child at any stage. More scientifically focused viewpoints try and give consideration to the levels of development, sensitivity to pain and suffering, or the point at which an unborn child might survive outside of the womb. But I think it's fair to say that there will be a very widely held view that at any stage a human embryo is afforded moral consideration beyond that of any other collection of equivalent cells. In the case of abortion, the law is designed to recognise this. Criminal law is the manner in which we safeguard the vulnerable and uphold the sanctity of life in our system. Abortion laws as they currently stand provide a structure to ensure the rights of everyone involved, including pregnant women and unborn children, are considered with a degree of fairness and that there is accountability. I will give way.
Hayes. For arriving late to the debate, Mr. Dowd, pleasure to see you in the chair, by the way. My honourable friend makes a salient point about the ethical issues around extinguishing the life of the unborn. But there's another salient matter, and that is the assumption on the part of the advocates of this move that individual autonomy, and we see the same with the debate about the end of life, by the way, individual autonomy trumps all else. That personal interest, dressed up as rights, are more important than the obligations to others, to society, and the duties to the country, and those greater duties to God. So I wonder if he'd like to comment on the philosophical rather than the theological aspects of that.
Whilst my honourable friend and I might not agree where we draw the line on each of those very complex issues in different circumstances, I absolutely sympathise with the recognition that individuals sit within society and we have a wider obligation, and sometimes laws and our customs are not there for the benefit of just the individual, they're the benefit of wider considerations. And so, Shadow.
I thank the Shadow Minister for giving way, and I do recognise the points that he's making, but he said there that criminal law was the way in which we gave effect to the framework he's talking about. Obviously, as we've discussed in this debate, there isn't a criminal underpinning to abortion in Northern Ireland. It's a healthcare matter, and it's regulated as healthcare. So for avoidance of doubt, can I just clarify with him that he would also accept that were we to do as new Clause 20 requires and introduce healthcare regulations that are human rights compliant to replace the criminal regulation, he accepts there would be regulation and there would be guidance about how services. It wouldn't create a gap, it would be a replacement.
What I said was that traditionally in this country, the nature in which we oversee and protect sanctity of life questions and those that might extinguish life is through the criminal law. Of course, the member is right to point out that in other jurisdictions, including in Northern Ireland, they might do it alternatively, but that is a tradition certainly in England and Wales, and actually in most regards in Northern Ireland too, and I don't think it's fair for the member to use an example of doing things differently to suggest that arguments different to that aren't valid. In fact, I found, generally speaking, the members' remarks during this debate to be quite insensitive to the complexities of the issues at hand and tempted really to focus more of her time talking about Trump than the kind of very delicate balancing act that very many people bring to this very morally complex issue. And if I continue, we must also remember that ultimately any prosecution undertaken by the CPS must meet the test for being in the public interest. And we mustn't confuse questions about the appropriateness of sentencing and the appropriateness of an individual decision to prosecute with an overall question necessarily of whether the criminal law in itself is right or wrong to be used as the mechanism through which we regulate this activity. Proponents of the decriminalisation often cite the World Health Organization's recommendation from 2022, which do advocate removing barriers such as criminalisation. Whilst these recommendations, of course, should carry weight with many, it's essential to view them through the lens of a unique societal context here in the UK. The World Health Organization's bulk of their recommendations are very much focused on countries which have a much, much lower rate of access to abortion in all sorts of different ways, and so that sits within a different context. Our abortion laws have evolved over time to reflect this delicate balance between the rights of pregnant women and the ethical considerations surrounding unborn life. And I would caution against taking a universal recommendation from a global organisation as a litmus test for whether we are or are not doing things correctly. And when prosecutions occur, they are no doubt distressing for those involved. But we also should be wary of changing the law in response to individual cases without looking at the operation of the law as a whole, and as I said, without thinking about whether there are other elements, for example, the operation of the law by the CPS, that have a bigger role to play than the law in itself. Accountability is a cornerstone of ethical practice, and criminal law serves as a mechanism through which accountability is ensured in many spaces. Without these safeguards, society is less able potentially to properly address situations where procedures are conducted wrongly. These are questions that demand careful consideration and proper parliamentary debate before any changes to existing laws are made. And as I mentioned, and others have mentioned, the amendment for the member for Gower and others will provide opportunities to do that. In its response to the petition, the government have stated that it has no current plans to change the law on abortion, and I'm sure the Minister will say more about that in her closing remarks. Whilst discussions around potential refinements to current laws are very valid and deserve proper consideration, I suspect a number of MPs would argue that the removal of criminal penalties must be approached with caution. As I've said already, the member for Gower has introduced a new Clause 1 to the Crime and Policing Bill, and members will know that debate on amendments laid to the previous government's Criminal Justice Bill did not happen because of the timing of last year's general election. Successive governments have adopted a neutral stance on abortion and treated it as a free vote issue. However, I understand the Policing Minister was unable to clearly restate that assurance during the second reading of the Crime and Policing Bill. It would be welcome for the Minister in her remarks to now confirm the government will continue to be neutral on abortion. Amnesty International has framed abortion as a human rights issue, advocating for its decriminalisation, but they must be applied in a manner that respects the rights of all affected parties, including the unborn. The ethical and moral considerations surrounding abortion are multifaceted, and these complexities cannot be overlooked. Before I conclude my remarks, I would like to say something about the tone of this debate. As we engage with this issue over the next few weeks and months, it's imperative that we consider the diverse perspectives and experiences that shape opinions on abortion law. I hope we'll all be striving to find solutions that uphold dignity, fairness and justice for all. The legal framework governing abortion must maintain an emphasis on protecting both individual rights and societal values. As I said earlier, abortion is an issue that transcends simplistic policy analysis. It's a matter of ethics, justice and the principles that define who we are as a society. The opposition believe abortion laws should remain robust, balanced and capable of addressing the complexities of these issues, and it will be for individual MPs to decide how that balance is best struck.
Jones.
Thank you, Mr Dowd. It's a pleasure to serve under your chairship today. And can I begin by thanking my honourable friend, the member for Folkestone and Hythe, for opening this debate. And can I echo the comments of the Shadow Minister on the tone of this debate and the topic as we move forward in coming weeks. I would also like to place on record my thanks for all of those who have signed and supported the petition that we are debating here today, as well as the petitioner Gemma Clark for raising this vitally important issue. This petition calls on the UK Government to remove abortion from criminal law so that no pregnant woman can be criminalised for procuring their own abortion. I recognise and respect that there are strongly held views, not only here in Parliament, but across the country, on what is a highly sensitive issue. And can I place on record my thanks to over the 200 people in my own constituency of Pontypridd who signed this petition. I want to make clear that at the outset, the Government does maintain a neutral stance in terms of changing the criminal law on abortion in England and Wales. I recognise that the Government's position of strict neutrality on this issue can be frustrating for all involved, none more so than me. If I were speaking in this debate today as the member for Pontypridd, my contribution would be very different. But thankfully my views on abortion are well known and proudly already on the record. It is for Parliament, Mr Dowd, to decide the circumstances under which abortion should take place, allowing members to vote according to their moral, ethical or religious beliefs. Let me begin by emphasising that the Government is committed, wholly committed, to ensuring access to safe, regulated abortions. All women in England and Wales can have access to safe, regulated abortions on the NHS under our current laws. In England and Wales, that access is provided through legislation set by Parliament, the Abortion Act of 1967. I know that honourable members have already stated the facts of the law today, but it might be helpful if I also set out the criminal law on abortion in England and Wales and the three main offences which apply. I should make clear that when I refer to matters concerning the law in relation to abortion, any reference is to its application in England and Wales. The law on abortion in Scotland and Northern Ireland is a matter for the devolved administrations. The Offences Against the Person Act 1861 provides two criminal offences that apply specifically to cases of abortion. Section 58 makes it a criminal offence for a pregnant woman to intentionally procure her own miscarriage by unlawfully taking drugs or using instruments. It is also an offence for another person with the intention to procure the miscarriage of a woman, whether or not she is in fact pregnant, to unlawfully administer drugs or use instruments. Section 59 makes it an offence for a person to supply or procure drugs, poison or an instrument with the intention for it to be used to procure a miscarriage.
The Infant Life Preservation Act 1929 deals with late-term abortions in England and Wales. Under Section 1 of this Act, it is an offence for any person to intentionally destroy the life of a child capable of being born alive before it is born, unless it can be proven that the act was done in good faith and only to preserve the life of the woman. Decisions to bring a prosecution under these provisions are for the Independent Crown Prosecution Service. In deciding whether to bring a prosecution, the CPS will apply the two-stage test in the Code for Crown Prosecutors. The first stage is whether there is sufficient evidence to provide a realistic prospect of conviction. The second is whether a prosecution is needed in the public interest. These criminal provisions should be read in conjunction with the Abortion Act 1967, which provides exemptions to the criminal offences. Under the 1967 Act and other accompanying regulations, women in England and Wales have access to safe, legal and regulated abortion services. These can be provided in an NHS facility or a place provided by the Secretary of State for Health and Social Care, such as an independent sector or clinic. In effect, lawful abortions can be provided for in the first 24 weeks of pregnancy, where two doctors agree that the continuation of the pregnancy would involve risk of injury to the physical or mental health of the pregnant woman or any existing children of her family. Abortions beyond 24 weeks are permitted if necessary to prevent grave permanent injury to the physical or mental health of the pregnant woman, where there is risk to the life of the pregnant woman, or if there is a substantial risk that the child would be seriously handicapped due to the physical or mental abnormalities. To reiterate, the government maintains a neutral stance on changing the law on decriminalising abortion. It is for Parliament to decide the circumstances under which abortions should take place, allowing members to vote according to their moral, ethical or religious beliefs. Honourable members will be aware, and they have been discussed here today, that there are amendments to decriminalise abortion to the Crime and Policing Bill currently before the House. Should they be selected, these amendments will provide this House with a further opportunity for a full debate on this issue. However, in answer to the questions from my honourable friend, the member for Gower, relating to the amendments, I cannot and will not comment on the policy behind the amendments, but I may draw attention to the House any practical or legal issues with the proposed amendments. The amendment tabled by my honourable friend, the member for Gower, seeks to disapply criminal offences related to an abortion from a woman in relation to her own pregnancy at any stage of gestation. This means it would never, at any stage, be a criminal offence for a pregnant woman to terminate her own pregnancy. My honourable friend, the member for Walthamstow, has tabled a separate amendment which is intended to introduce a human rights framework for future regulations related to abortion and protect existing abortion rights. The amendment repeals several criminal offences in their entirety, meaning it would never be a criminal offence for a pregnant woman or anyone else to terminate a pregnancy. While the stated intention is clear, the practical effect of this amendment is more limited and the powers unclear, which could give rise to unintended consequences. Should these amendments be selected, these amendments will provide the House with a further opportunity for a full debate on this issue, and if the will of Parliament is that the law in England and Wales should change, then the Government would not stand in the way of such change, but would seek to ensure that the law is workable and enforced in the way that Parliament intended. I will happily give way.
I thank you for giving way. Obviously, what New Clause 20 does is introduce what we've done in Northern Ireland, here in England and Wales, and I know from her previous comments that she's been very supportive of that legal and moral duty to act on the record. So just for avoidance of doubt, can she clarify whether her officials have met with the Northern Ireland Human Rights Commissioner to understand how this operates in practice in Northern Ireland were it to be introduced in England and Wales?
I will happily come back to her with that information once I've spoken to the officials to find out exact details. As I've said, the Government remains neutral on the policy, but on the workability and practicality of the amendments, it is something we are currently looking at, and I will happily discuss that with her at a later date. Wherever one stands on the issue of legislative change, I commend colleagues for engaging in this debate, and while Government, again, as I will state, is neutral on this issue, I do want to close by thanking all honourable members for their careful consideration of these issues, by thanking the campaigners who have shared different perspectives and recognising that the many people who have written to their MPs and shared their personal experiences. Thank you, Mr Dowd.
Tony Vaughan to wind up.
Thank you, Mr Dowd. I again thank the petitioner Gemma Clark for starting this petition, which is being debated, as others have said, at a crucial time given the proposed amendments to the Crime and Policing Bill, which have been debated today to a degree. But what is clear is that abortion investigations and prosecutions are on the rise. And despite their relatively small numbers, what has come across in many honourable members' speeches is the recognition of the culture of fear which flows from the criminal law. We've heard of Sammy's case, victims treated as suspects, 7 police officers raiding a house, searching bins, phones, health apps, all at a time of deep vulnerability. Many honourable members have referred to the centrality of choice and individual autonomy, as I have. Some on the opposite benches opposite have raised the value of the life of the unborn child, and it has also been said that autonomy was almost being treated as a trump card by those on the decriminalising side of the debate. That is not something I hear or recognise. A human rights approach will always balance the competing rights that I've just referred to. That is what the Supreme Court did in the Northern Ireland Human Rights Commission case when it found that the rules at that time were incompatible with the law. There is always a backstop of preventing inhuman treatment. But there was no real rebuttal to the proposition that public attitudes in England and Wales overwhelmingly support decriminalisation. And it follows that Parliament should respond to that. I again thank the petitioner for presenting this House with an opportunity to consider this crucial issue and thank everyone for participating in the Petitions Committee process. Thank you.
Thank you. The question is that this House has considered E-petition 700014 relating to decriminalising abortion. As many as are of that opinion say aye. No. Of the contrary, no. Order, 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 order. My opinion as to which side is in the majority has been challenged. Under paragraph 13 of Standing Order number 10, the question is therefore not decided and that shall be reported to the House. It is possible for the question subsequently to be put to the House for decision without further debate. Order, order.